Thank you. Thank you. I first want to thank Ray and his colleagues at Above Security for inviting me and hosting you. It's a bit intimidating for me to be here in that I am a fairly typical American. I speak English and enough Spanish to know not to smoke on the bus in Miami, okay? But beyond that, I've been fortunate to have had a considerable amount of international experience, usually originating from relationships in the US, but also because years ago I decided to become a student of the offshore tax world. And a lot has happened in the last 20 years. And when I was asked to talk a bit about fiduciary responsibility, I thought that what I would try to do is try to present that in a way that could be understood really within the context of many things that are happening today internationally and have happened internationally really since 9/11. Because even prior to the 9/11 attacks in the US, is everyone familiar with the Organization for Economic Cooperation and Development, OECD? OECD is an organization that was formed in Europe after World War I to provide for rebuilding of Europe. But what has evolved from that organization has really been an initiative to clean up some of the abuses that accompany some legitimate enterprise, most notably in the tax arena. There are many countries around the world that were known as tax havens, and a lot of shopping that went on to get more beneficial tax treatment. There have been many of those loopholes have closed, many countries have changed. I was in Liechtenstein 5 years ago to help someone do a tax planning project, and 5 years now, Liechtenstein is no longer a tax haven. Similarly, Switzerland was known for its bank secrecy, and a whistleblower reported that UBS was facilitating tax evasion in the US, and now suddenly subpoenas were flying, executives are prosecuted, and there's a whole new perspective on fiduciary responsibility. And that is something that I thought I would use as kind of the foundation for my topic today. And I'd see if I can. I'm going to skip through a lot of the technical information on the Patriot Act and come back to it a bit later and in our roundtable discussions. But there is an evolving standard in the world about what responsibilities executives have with respect to protecting information, sharing information, and deciding, how to gather it and what to do with it. And there's a US perspective where there's an evolved sense of fiduciary responsibility, which is somewhat duty of loyalty and duty of care that executives must exercise. And when we look at the executive levels, we have issues in many companies, in fact in all companies, where you have a company and its owners, you have a board of directors, and you have different levels of management. And whether someone is an information technology officer or a senior executive, there are various responsibilities to the company, and the company has various responsibilities to governments and to the law. Now, within the context of various developments internationally, you do have the US Patriot Act, which the US implemented to protect itself after 9/11, but has used much more broadly to gather information, not only to combat financial crimes, but also to use that as a foundation for raising revenue through tax evasion. There is the 2012 EU directive, which after several years of realizing in the EU community that the US Patriot Act suddenly was giving too much access to what was otherwise considered to be secure information in the EU. The EU adopted a very broad and comprehensive set of rules on protecting information technology and rights of privacy. So you have a US Patriot Act, which the US, of course, tries to use effectively and broadly. That does not displace national sovereignty, which is important to not ignore. You've got a 2012 EU directive, which is new, comprehensive, and I recommend it to you that those of you in information technology and management understand it better and make sure your lawyers understand it. We have a law in the US called FACTA, the Foreign Account, essentially, information law, which is another attempt at the US government to make sure that US citizens don't go offshore, have substantial financial interests in financial institutions or other business enterprises without the US government getting its fair share of taxes. It imposes a burden on foreign financial institutions and others to do reporting, but it's also used as a basis for gathering more information on citizens. And then you have the OECD. So in viewing fiduciary responsibility globally within the context of management, there are tax considerations, there are money laundering considerations, and there are national security considerations, all of which impact on the way that information is gathered and protected. For those of you who are not necessarily familiar with fiduciary duty, it's fairly well defined in the US, but the US is made up of 50 separate states. So there may be a general concept of what duty of loyalty and duty of care and duty of good faith, but those standards evolve, and now there is I'd say some more refined concepts that have come out of some recent things in the US, like the Madoff case, which was a multi-billion-dollar Ponzi scheme, and then evolving standards in the offshore world, initially coming from the Cayman Islands. And this is an important point with respect to information technology and use of consultants, because there's this case, this Weavering case. It really established new standards for director responsibility. And I think it's important to understand that because many of us properly rely on consultants, lawyers, those of you who are in business to provide services. And it's important that management realize that if you are a director of a public or a private company and a government is looking to you to manage your information responsibly, then the board of a company cannot just say, well, I hired you to manage that for me. And companies like Above Security truly understand that there needs to be a partnership, and it's not a partnership where that responsibility is just turned over to Above Security, but it needs to be an interactive, holistic process in which there is mutual recognition that this evolving standard of having a responsible party, government's looking for someone to be responsible if there is tax evasion, if there's money laundering, if it's determined that a government feels that there's a support for terrorist activity through financial means. So when I kind of look at a broad template, I look at concepts of transparency, because one thing that many of these laws attempt to obtain is that there not be secrecy between governments, that if the US wants to prosecute someone for tax evasion, it comes to a country in Europe, or it comes to what was previously an offshore jurisdiction that was known as a tax haven, that there be mutual cooperation to get information. This initiative in transparency and international cooperation certainly bumps against issues of privacy and issues of national sovereignty. The US likes to throw its weight around, saying you want to have a good relationship with us, commercially, you want our assistance, then give us information on tax cheats. Give us information on people who may be using banks offshore that may have some relationship with the US for money laundering and other criminal activity. And that then bumps into rights of privacy, management of information, and national sovereignty. And many lawyers in the US and many people in the US think, well, okay, the US has this Us Patriot Act, which is pervasive, and that's just not true. Any government that tries to reach out and impose its will on the citizens of another jurisdiction has the right to defend itself and make sure that information is being managed and processed for legitimate purposes. I have had a lot of focus on tax matters over the years, and I think that in the US, we had a very famous criminal in, I guess, the 30s, Al Capone. Do you even know Al Capone? Well, the US government couldn't successfully prosecute Al Capone for murdering people. But what the government did was successfully prosecute him for tax evasion. And tax evasion really has become a major premise and major foundation for pursuit of many government objectives which go beyond tax evasion. I think that because of I would say the breadth, the extent of the subpoena powers of the US Patriot Act, and now this EU directive, I think there's going to be even more increased focus on the effect of banking institutions, telecommunications, ISPs, and IT security companies. And I think that within a company, I think it's very important that if you look at these international initiatives and the codependence and interdependence of these various rules today on information, it's very important that there be a legal structure within a company, a legal and a management structure within a company, so that there's recognition that the board of directors understands that there is this responsibility. It's properly correlated and coordinated with the lawyers, the inside and the outside lawyers, that whatever tax compliance exists within the company itself, it has dedicated or outside tax compliance, that be brought in, and that all be harmonized with how you are gathering, protecting, and sharing your data. And I think that maybe until the last 5 to 10 years, there were many separate functions. It was never really thought that there was interdependence as much as there is today, given the international interaction with data. Data now flies freely around the world instantaneously, and it's very easy to lose touch and lose responsibility over it. And I like to use the UBS case as a perfect example. There's an example of centuries and centuries of Swiss bank secrecy being destroyed to a large degree, rebuilt, and executives who never thought that they would have criminal exposure being prosecuted because I would say everyone felt that they were safe and that they were being a little too cute. You know, it's sexy in the US, to talk about saving taxes. Taxes are a big issue in the US. And even though I've been knowledgeable about the offshore tax world for many years, it's remarkable how often I interact with executives, investors, who say, oh, my friend has an account here, has an account in Jersey or Guernsey or the Cayman Islands or the Seychelles, and he doesn't pay any taxes. And I said, well, you know, if your friend is doing that, your friend is going to go to jail. Similarly, people, this is not a political statement, but they say Romney has accounts in the Cayman Islands. Well, Romney pays taxes on those accounts. Now, FACTA, which is really not well understood in the US, was a way of ensuring tax compliance, but it's also a way of combining with the USA Patriot Act how to get more and more information and also using that as a pretense for getting more information on companies outside the U.S. who otherwise may not have been within the ability of the U.S. to get that information. And that's always an interest because of there is a lingering offshore industry in tax shelter and tax havens, and there's a legitimate exercise of those rights in business. I always laugh a bit because people in the U.S. and the U.S. government may criticize tax havens, but at the same time, many companies within the U.S. and other countries will shop locating their businesses from state to state to get more favorable tax treatment. Another thing that FACTA has done in combination, thank you, yes, with the USA Patriot Act is the focus on the integrity of the banking industry. For example, the USA Patriot Act has a prohibition on interaction with foreign shell banks. Now, one thing about the information age is that the model of traditional banking has, in many respects, changed. The traditional concept of a bank is a building with fancy doors and fancy desks and some degree of privacy in the private banking realm. The U.S. has legitimate internet banks without any bricks and mortar, as we like to say, and there have been many cyber banks that have been established throughout the world that support illegal activity. So one thing the USA Patriot Act recognized was that is not something the U.S. will tolerate, foreign shell banks, and as you process information and as you gather information and engage in business, and as there's a flow of money within your company, it's very important to realize where that money is coming from and where that money is going. There are legitimate and illegitimate enterprises which do launder money, and I think that as you manage your information and as you look at these enforcement tools that the U.S. has implemented, that the EU has implemented, and I think that will continue to evolve as there's more of a recognition of the interdependence of many of these issues, then there's going to need to be an understanding of how significant this information is and how not to share it irresponsibly. That's different from protecting it if a government wants access to it. But many executives can get caught unknowingly and prosecuted unknowingly by being an unwitting party to financial fraud. And I think that as management and companies like Above Security are assisting in how to manage that data and how to present it and protect it, it's very important to recognize that not to just have a very narrow focus. I think we all sometimes think we have a very specific technical focus on protecting data, but that has much more far-reaching consequences today, and I think will in the future than ever before in history. And thank you.